about.
Hey, man.
Talk shoes.
Recorded
Hey,
live.
man, how you doing?
Hey, what's going on?
Hi, Rod.
Not a whole lot. I got somebody pointed something out to me. Court case, Ben Hollow versus Donanis, administrators, 3 U.S. 54.
That's an old case, right?
Yeah, Supreme Court of the United States. Inasmuch as every government is an artificial person, an abstract, and creature of mind, only a government can interface only with other artificial persons.
Okay, we've dealt with this in the past,
Yeah.
and if you go back and check that case, it deals with a board ship. And you try to go back and that phrasing, and you can't find it in that case law.
Yeah, that's true. Yes. I have a whole thing where I went through and I analyzed it and looked for it and couldn't find it. So I think it was, unfortunately, maybe one of us in the movement who may have been a little over enthusiastic. You know what I'm saying?
I'm not saying that we can't use it, but if you ever get questioned on it, you better be able to back it. You better be able to support where, because that deals with a board ship.
Oh, yeah? Well, still,
Yeah.
what they did, they created a fiction in the all capital letter name.
I understand that, Al. I really do. You know,
Dealing with fiction. Brought in a real man, made a judge a real man. They couldn't deal with that in their administrative court. Throw it out.
all I'm saying is watch, because I have seen that. That's been out there for quite a few years. We've used it on some of our court cases.
Yep.
And the question come back on that is, all right, here's the court case. Show me where you found that wording in this court case.
The case is called Penhallow v. Doanes, D-O-A-N-E-S, and just use that if you're going to search for it. But, yeah, I went through that 9 ways to Sunday. I could not find that exact thing in that case. But
all right.
No, it's not in there. I've tried to find it, sir.
Okay, let me get people muted. We'll get started here in a minute. Hold on.
I am unmuted.
All right, Carl's on, Harvey's on. Go ahead, give your updates. I have been down here for the last couple of weeks. I've been dealing with health issues.
Who do you want to go first? Sorry to hear about that. Who do you want to go first?
Go ahead, Harvey. Go ahead and do your. Then I'll have Carl come and give his updates, and we'll go ahead and get rolling.
Okay. My only function is to say hello to new callers, people that haven't listened before and don't know about the Big List. Big List is an automated email system that if you want to join it, you may. It's very simple. It'll keep you in the loop, let you know when the calls are, documents happen, stuff like that. All you do is send an email to Rod, R-O-D, dash, class, C-L-A-S-S, dash, subscribe, S-U-B-S-C-R-I-B-E, at Ray Servers. It's like a guy's restaurant. Ray is the restaurant owner, and he serves. So it's Ray Servers. So it's rod-class-subscribe at rayservers.com. That's basically it. It'll keep you in the loop, hopefully, and it's automated. Can't contact anybody from it, but it's just an automated list that's 1,800 plus people big at this point, and that's why we call it the Big List, because there's a big amount of people on it. And that's all for me, Rod. Thanks. Hello? Still here? Hello? Oh, no. Ooh. What the heck happened? Did I overmodulate?
Yeah, can you hear me?
You're going, Harvey.
Oh, okay.
Can you hear me, Harvey?
Yes, I can hear you, Carl.
Thank you.
I don't know what happened to Rod.
Oh, I hit my mute button because my wife come in and talked to me.
Oh, okay. I thought we had gone away just for a moment there, and I guess we had. Anyway, so I'm all set, Rod. And
All right,
Carl?
go ahead.
Yeah.
Go ahead, Carl.
Did Sharon raise her hand?
Yeah, she did.
Well, ladies and gentlemen, I'm starting to get excited. I'm getting my time freed up here. It's the holidays again after many, many years, and I was just sitting here a while ago thinking about how many times and how many holidays Rod's been on, I've been on. You know, we went to many, many years of time. I know I've been out of pocket for a while, but you know, I've seen the mark on my email and the update that there's going to be a call tonight, and of course Rod and I talk sometimes one-on-one and about some other things, but you know, I'm starting to get excited again. I'm getting my time freed up here and my life back. I don't want to get off into all of that because it's just one day at a time here, but something that I did notice here, when was it, a week or so ago, I seen one report come through on my list that I get, and it goes back to these foreclosures. And apparently there was some money and funds paid out in a criminal and civil case. I don't have that in front of me, so don't send me asking for information because you'll have to research it yourself. But there is a fund account where people can go back and file a claim. If they've been misled on their properties, et cetera, the bank's taking advantage of you, whatever. So anyway, I'm just in a turning point here, turning the corner, and I want to start getting more excited here after the first of the year and start doing paperwork again, it looks like. So that's basically all I got, Ron.
All right. Thank you. Jeanette? Jeanette?
Yes, I'm here. Can you hear me, Rod?
Yeah, go ahead.
Hello, everybody. I'm glad to be back on call again. Good to hear you again, Carl. I have had the opportunity to borrow an individual's computer and a few hard drives, and in the past few days I've gotten a few thousand, literally, a few thousand more pages. Rod and I will be doing a private call in the near future. I will be laying this out. It will be expelling this all out for everybody across the country. Y'all know that I do a lot of research for Rod. Y'all know that also that when I'm loose on the beach and I turn over every grain of sand on the beach, not one is left unturned when I do my research. Again, I've been very busy. You know, I'm after the banks, I'm after the Pope, and I'm after the Vatican. I have gotten a little bit of research done on this, a little meaning substantial, and I fully plan on exposing this. We also have one of our listeners and one of our avid researchers who's going through a lot of issues right now. The very corrupt attorneys seem to think that it's okay to have taken everything from him, his properties, his home, his wife, his cars, his bank accounts, put him in jail, and they seem to think that that game is not over. So part of my research, I fully intend on putting their names out there over the airwaves to totally put them in the Hall of Shame. So I'm not through doing what I'm doing. Again, since everything I've had has been stolen, not a problem. It's not stopped me. Rod and I will be putting this out there. I just need to put this together so it's very eloquently presented. And hopefully we can get that done in the next few days, okay? So on that note, it comes back to one word, and it starts with the word bank and ends with the word bank. Other than that, I'm not going to disclose any further information on that. Rod, take it away.
All right, thank you. All right, ladies and gentlemen, tonight's topic goes back into biblical, where the Bible gets in and says, those who can hear and those who can see. If you can hear and understand and you can see, you'll know what's going on. Ladies and gentlemen, for you new people on the line, there is an extremely amount of knowledge and education in the archives. One of the biggest things that what we're doing here is that you have to be able to remember what was said and what we are exposing. You've got to be able to associate. You've got to be able to put it together. One piece, one single piece is not your answer. And this is part of what people are looking for. Majority of the people are calling me with what we have for information out here. Ladies and gentlemen, the information is sound. Our problem of it is enforcement. Mm-hmm. The biggest issue comes down is the lack of people wanting to participate and remember the knowledge of all this and come in here and go blazing with what we've done. Because if you get back into the last several archives, we talked about lawyers. We talked about attorneys. There is a distinct difference between an attorney and a lawyer. Now, they want to use it as interchangeable. They are not. An attorney comes out of the Judiciary Act of 1789, which goes back to the Attorney General's office. It goes in under Volume 10 of the Statutes at Large. And you look in at the word attorneys, it always refers it back to the Attorney General's office. There is legislative law that created the attorney, but that is for the prosecution side. That is not someone who comes in, well, we're going to appoint you an attorney on your side of the fence. That's supposed to be a lawyer. But like we have recently discovered, and we put it out, for you new people, get into the American Warriors 1907. It's a PDF. Get in, read it. It goes back in and addresses the fact that the lawyers go back to 200 BC. Not in the book, but if you go back and check the history of lawyers, it goes back to 200 BC. They came in as a next friend. They come in as someone who's capable of speaking. That's what this book gets into, the American Lawyers of 1907. They're coming in as a friend of the court. They're coming in as a spokesperson on your behalf because you're not capable of speaking the language. These are all pieces to the puzzle. I want to read something to you. And I want you to think about what I'm going to read here. This code is the official reinstatement and convention form of the general and permanent laws of the United States enforced on December 7th, 1925. Now scattered in 25 volumes, i.e., the revised statutes of 1878 and volumes 20 to 43, inclusively of the statutes at large. No new laws is enacted, and no laws repealed. It is prima facie, this law, or the law. It is prima facie, the law. Prima facie. What's prima facie? Harvey?
You're looking for a definition? Prima facie means that there's everything points to the fact that there is a law there, but it's not necessarily there.
Okay. It is prima facie the law. It is presumed to be the law. The presumption is rebuttable by production of prior unappealed acts of Congress at various with the codes. It is presumed to be the law. What does that mean, presumed to be the law?
Oh, we think it's the law, but it may or may not be the law, and that's why you really need to go to the original document in which the law appears to find out whether or not the law they say it is the law that it actually is. There you go.
Okay. Now, I brought this up many moons ago up on this show. Volume 43, the Statutes at Large. It stops on March 4th, 1925. Volume 44, Part 2, picks up on December 16th, 1925. Now keep those two dates in mind. Volume 43 stops. And what's it mean when it stops on March 4th, 1925? What does that mean?
That volume's done with, maybe? I don't know.
Yes, it means this is it. This is done. We've come to the end. What's it mean when it says starts on December 16th, 1925?
The same volume?
Nope, volume 44.
So is the same volume stopping and then restarting again?
Volume 43, Statutes at Large, Volume 43, pictures in your head, people, stops on March 4th, 1925. Volume 44 picks it up on December 16th, 1925.
So they had to take some time off and took a vacation, right?
Basically, yes. Now stop and think here. How many months is between March and December?
April, May, June, July, August, September, October. 8 months, 9 months?
8 months.
All right, so you got 8 months here where Congress didn't put anything in the statutes at large between Volume 43 and Volume 44, Part 2. Now, let me go back and read this again.
That's because they all had diarrhea.
Yep, this code is the official restatement in convenience form of the general and permanent laws of the United States enforced on December 7th, 1925. December 7th.
December 7th. So it's saying that all the titles are as of December 7th, yet another volume, volume 44, came out on December 16th?
Yep.
That seems a little strange.
Well, this is what we're coming in. This is why it is saying it is prima facie the law. No, it don't, Sharon. Probably either in the bedroom or. And it says it is presumed to be the law.
That's what prima facie means. It's a presumption. Prima facie is a presumption that what is being stated as the law is the law. However, there's room for doing more research to see if what's being stated is exactly what was written.
Actually, gentlemen, the words prima facie means on its face. It means the evidence on its face. Prima, first, and facie is face. It means the evidence on the face.
Like the evidence, as far as we know, is true.
As long as it is written in the statutes at large. But when you got Volume 43, that stops on March 4th, 1925, and you got the next volume, what comes after 43? 44. If 44 starts on December 16th, 1925, and there's no listing for December 7th that was placed in the book to create the United States codes, then how can the United States Code have any validity? Because they was only passed by Congress. That's historical. It was only passed by Congress. It was never passed by the Senate. That is
by Congress, you mean the House of Representatives as opposed to the Senate?
Yes. This is a historical fact. Now, a lot of you people are sitting here saying, well, Rod, Title 18, there's no documented history of the Senate ever passing Title 18. What between 1 and 50 does 18 come in at?
It's right there, somewhere.
So if Volume 1 to Volume 50 was never passed, and Title 12 is banking, Title 26 is IRS, and Title 18 is criminal. This stuff was never passed, ladies and gentlemen.
Passed by the Senate.
Exactly.
And it really needs to be passed by both houses, the House of Representatives and the Senate, right?
Right. Now, we brought up here on this show, and I really begrudging giving this out on the air because some of you should have been, or most of you should have been able to sit down and figure this out throughout the period of time that we have laid this thing out. But because of the damage that is being done to us by foreclosures, IRS, criminal charges, you name it, they're doing it to us. They have taken advantage. This is why when we brought up about the American Lawyers of 1907, that book goes in and explains that they're not educated in the law. They are taught theory. They are taught concept. They're professors, according to the book and for what we're finding out, never been inside of a courtroom. They're teaching the students how to walk into a courtroom when they themselves has never been there, and they're not teaching them law. They're teaching them theory. They're teaching them concept. This is where the Bar Association comes in at, ladies and gentlemen. This is, if you get in, the bar prevents you and I from being able to represent ourselves with standing in the courtroom. Now, a lot of this, what we've been dealing with here over the last years, we have been laying this thing out. This American Lawyers 1907 was the piece that we needed that verified that the lawyers are not educated in law.
And a sidebar, that book, the link to that book is in today's big list. So, if you've not read the book, it's in the big list, and there's a direct link to it. So, have fun with it.
Yes.
Well, that makes me think back to what we've talked about for years is process and procedures in these damn colleges out here, people wanting to get their law degree and put their little plaque on the wall. You know, okay, well, I passed the bar, so, you know, it's just...
Now, I have tried throughout the years to go very slow and try to spell this stuff out. to try to make it as clear as possible. It's coming down. I can't make it any clearer than what we're sitting here saying. Those who have ears to hear will hear.
Sure.
Those who have eyes to see will see it.
Mm.
And those who have a stiff neck will never learn anything. This goes back into the biblical side of this. We've got to be aware of what's around us. We've got to understand what's being said. The argument in these courtrooms, ladies and gentlemen, is the fact that USC codes under the Federal Register, when they created this thing, they put an administrative committee in charge. They left the President of the United States to go in and codify the statutes at large. The administrative codified it for the administrations. That means that the CFRs and the USC codes are purely 100% administrative. It only applies to their side of the courtroom. The challenge in this is going in and challenging the attorney, which is, and I'm not misquoting it, I'm saying the attorney, which is the prosecutor, challenging him to validate where any of the USC codes, if you're in federal court, whether you're in an IRS case, whether you're in a foreclosure, whether you are in a Title 18, where is the verification that this was passed by both houses? They cannot prove it, because what I read to you came out of Volume 44, Part 1 of the Statutes at Large. That says it is prima facie the law, it is presumed to be the law. Ladies and gentlemen, use your ears to hear what was said. Use your eyes to read Volume 44 on that preface, Part 1. Use your ears to hear, use your eyes to see, and use your mind to understand. This has nothing to do with 14th Amendment citizens. This goes back in and shows when they created the USC codes, they never passed them. It's a presumption. It is presumed to be law. This is why you and I are forced to hire a lawyer. That's why he said, well, you got to have a lawyer. You got to have a lawyer represent you. You got to have a bar member represent you. That lawyer cannot bring this up. The attorney for the state will not bring it up. And the judge sits here in ignorance because it was never put before him to have it clarified, or put before a jury to have it clarified. We need to challenge the laws, have them produce the verification that they were passed by both houses, and they can't. They can't go back now and refix this because it's already in Volume 44, Part 1. It's already put black ink on white paper. It's telling you it's prima facie. It is presumed to be the law. It's an assumption that it's a law. This means every foreclosure is based on a lie. That foreclosure is based on public official side of this thing. They have to sit down and take account for their mortgages. They're the ones who have to do the IRS side of this because they're the ones who are receiving pay. They're the ones who are receiving pay from our labor.
they're the ones receiving pay for when we or the people making mortgage payments. When you make a mortgage payment, look on your bill.
You and I do not have to pay mortgage payments because the moment we sign our name under that bankruptcy of 1933, under Title 12, 95, 95A, 95B, and Title 12, 411, we come under that state of emergency clause. Our signature is our worth. Once we sign that promissory note, then that house is paid for. On the other hand, when a police officer or a clerk of the courts or the mayor's secretary or the mayor or the governor or the legislators, when they buy a home, their wages come from our labor. They have to account for where they're spending their money. You and I don't have to account for it. This is what we have been exposing. This is what we're coming up with. Now, I've had several people have tried to contact me. And again, stop and think here, ladies and gentlemen. I have an ankle bracelet on. You want me to hop an airplane, go through Homeland Security, go through a metal detector, and I've got an ankle bracelet on, and you want me to fly across the country? You think really Homeland Security is just going to sit and say, oh, well, Mr. Klaas, go on by. You know, we know you got an ankle bracelet on. Just go right on through. You don't think they're not going to stop me and harass me for a while? Ladies and gentlemen, let's stop and think here about what we're asking me to hop in an airplane and go do.
Well, you got to have your veterinarian papers.
Yeah, I understand that. But ladies and gentlemen, what we're getting into tonight, what we have been trying to put out, and the reason why I'm reluctant about this is very simple. Because now we just opened it up for any rapist who is out here who wants to rape your daughter, rape your wife. We now gave him the avenue to come in here and do it, and it can't be prosecuted because there's no laws under their setup, or a murder.
Yeah, I think we got into that here a few years ago about some cases, didn't we?
Yes, we did. You know, that's why I've been trying so hard to give you the pieces, but people are not catching it. They're not figuring it out. They're not sitting here thinking about it.
Well, I tell you what, Rod, I spent the last 2 years, there again, not to get into detail, taking care of the elderly, and, you know, I'm starting to have my time freed up again, and my brain is starting to click, and I'm getting excited.
Good. You know, you need to take care of your family, and you did. You know, that came first. But ladies and gentlemen, what we have been getting into, it really boils down to when you're walking into that courtroom on a federal court case, is that you sit here, you don't challenge the judge. You expose it to the judge.
Yeah.
You challenge the prosecutor, and you have them produce any legislative law that created any of the USC statutes that were the Congress and the Senate both passed them in 1925, and they can't. Well, Rod, we got proof that they passed them in 1948. Ladies and gentlemen, you can't pass something in 48 when they said they did it in 1925. They can't amend anything if it doesn't exist. Now, what they did on June 30th, 1926, just because they published them, just because they had Westlaw, put them in Westlaw published books, and they're sitting in every law library across the country, just because they're published doesn't make them law. They had to be passed. And in every single law book, you will see the word prima facie in it. It's prima facie law. They're telling you right up front it's prima facie.
Well, what's the difference between facie and prima facie?
Well, prima facie, it's all the same, Carl. Prima facie is what we're saying here.
Yeah, I know that. I'm just throwing a question out there to get people to think.
Yeah. But, ladies and gentlemen, this is what we're sitting on. This is what we've been trying to get you people to understand. You're making it so hard on yourself of what you're trying to do here. And what this goes back in and explains is the very thing, the whole argument you're walking into this courtroom with on the federal side is these are not laws. These are codes. These are administrative procedures.
Yeah.
This is what Volume 44, Part 1 gets into. This is what it explains. It may have created codes, but they was never passed by Congress. Lawyers, there is no legislative authority that we have found that deals with lawyers. They're nothing more than a next friend. They're nothing more than a friend of the court. And if we would start challenging this on IRS cases, start challenging this on mortgages, where does the lawyer from the bank, where does he have interest in this? He is nothing more than a friend coming in here. He's nothing more than a paid mouthpiece. What is your education? Was you trained in the law? Was you trained in theory? Start challenging his credentials.
Your Honor,
Well, yeah.
Your Honor, I have an objection. I object to this proceeding because I did not give my rights or my authority over to this bar brain that's a public defender.
All right, Harvey, go ahead.
I forgot what it was. Sorry.
Yeah.
I'll come back in. The thing I was going to say. If the lawyer is a next friend to the court or whatever, isn't the lawyer dealing hearsay information?
Yes, he is.
Well, see, that next friend was set up for the people. It wasn't really actually set up for the lawyers. The damn lawyers took that authority over, abusing it.
Well, they took it over with the blessing of the administration or the infrastructure or the court, the government.
Yeah, back to process and procedures.
It goes back to where the Bar Association stepped up in, and the judge is only going to allow bar members to present any case before the court. And ladies and gentlemen, you now have that foundational argument that lawyer does not have legislative authority to walk into that courtroom. They can't produce any legislative authority. The only thing that they're going to be able to produce, well, Your Honor, we have code of ethics. We have code of professional responsibility. And that's exactly the words you want to hear, because the moment you do, you can slam them with that. Because under their code of conduct, their code of professional responsibility, they cannot mislead, misrepresent, misconstrue, and put false information before the court. And the moment you challenge them on the law side of this, where is the legislative law that created the USC codes? Where's the law that was passed by both houses? They cannot produce it.
No.
It is not just Title 18, ladies and gentlemen. It is the entire books, all of them.
So can we say that maybe it's they're calling it prima facie, but what about their side of the face of the prima facie? And I probably lost a lot of people there, but
Oh, you lost me. Well, what are you getting at?
well, I'll get back to it.
It appears to me that it's prima facie administrative procedures against the administrative people in the government.
Well, there again, you have to think. Let me say it this way. You have to have in your own mind like two brains. You know, we got the left side, we got the right side. We think as we do. You know, is it real? Is it Memorex? Is this, Your Honor, is this right? Is this what's supposed to be happening here? You know, I'm getting screwed out of this deal, and this public defender's wanting to file more continuances so he can get paid his check longer.
What it does, it keeps you in the system on the Chris account longer so they can sit down and get their 90 days in or 120 days in for their stock exchange.
Yeah.
But, ladies and gentlemen, the point, the issue, the fact that this isn't an assumption. This isn't, well, Rod, you're just bringing this up. I'm telling you exactly where it's at. It's in Volume 44, Statutes at Large, Part 1, Preface. It point blank says it is prima facie, the law. It is presumed to be the law. Presumed.
Now, Rod, one thing you brought up currently is when you see their books of the codes or whatever, they don't do that preface anymore, do they?
Yeah, I got them in Title 28 because, well, what I did when I was in D.C., the prima facie side of this is still in there because I showed the lawyer because they have to put it in there.
Yeah, in the book. But on the internet, when you get a copy of the codes, it does not include. That's what I was trying to get at. It doesn't include the preface, right?
Yeah, it's not on the internet. It's only in the hard copy books.
And eventually, everything is going to be in the cloud. So we're screwed if some of us don't save those books.
Exactly. Ladies and gentlemen, the argument is not about whether I'm a 14th Amendment citizen. The argument is not whether, I'm a Northerner or Southerner. The argument is, and we need to bring this judge in as a real man. We need to come in here as a real man. We need to make this judge a real man sitting on that bench or a real woman sitting on that bench. And then make the issue in that courtroom on the prosecuting attorney and challenge the law on this. And the judge can't say, well, we're going to no, you can't bypass this. The moment you bypass it, you know that there's no standing in law in this courtroom. We want it addressed. We want it proven. Because they cannot prove it. I'm handing you the information right here. I'm telling you exactly where it's at. I have told you people. We've also went back in and explained about the lawyers. We've also explained about the Federal Register. We explained about the Administrative Procedure Act. We've also went back and explained the bankruptcy. Ladies and gentlemen, it's a combination of all this. It isn't just one, it's the combination of all of it. It's the argument. We have come a long ways because I had some gentlemen that stopped here. One of them was a judge. I'm not going to give his name out, but one of them was a judge. I ran into him before at one of the workshops. I met him again here because they come down to the house here. I walked him through this. I laid all this out. They were surprised and very shocked. We brought up about the lawyer, and I showed him the American Lawyer of 1907. He got into it and read it. We're being forced to hire a lawyer and take on a lawyer as a public defense counsel in order to cover this up because they cannot bring it up. The prosecuting attorney will not bring it up, and as long as that judge remains ignorant, then ignorance is bliss, and he can get away with whatever he wants to get away with. Because now he has immunity because he doesn't know. He wasn't aware. Had I had known it, had that been brought up, but the lawyers aren't going to bring it up, the prosecutor isn't going to bring it up, and we got to go back in and make the issue on this. This isn't a very hard issue to come back in and make, ladies and gentlemen. This isn't a very hard argument to get into.
How can the judge be excused for not knowing? Isn't the maxim ignorance of the law is no excuse?
Yes, it is, but as long as you don't put it on the record,
As long as you don't object.
You don't object. As long as it's not on the record and you don't object, then he could claim ignorance, even though he was a lawyer at one time.
So that's why I object.
Well, see, that's, Harvey, that's why most judges don't like pro ses or individuals coming in the courtroom without an attorney because they do things different.
True. They bring up the warts, and they want the warts discussed.
Yeah.
But I got a hold of, someone sent me, and I appreciate it, an American Jurisprudence 70, Volume 70. It gets into sedition. The sedition law of 1798 provided, among other things, for the punishment of any person who published any false or malice thing against the government of the United States, or any material intended to excite the people to oppose any law or any acts of the President in pursuit of the law, or to resist, oppose, or defeat any law. Definition: sedition has been determined or has been defined as a common mode, the raising of a common mode in the state, not amounting to an insurrection, or the excitement of discontent against the government, or the resistance to unlawful authority. This gets into, it talks about disloyalty. Willful and knowing utterance, writing, or publication of disloyalty, or abuse, matters against the United States, or a state, or a flag, or a military force, or uniform of the nation, which matters is designed and calculated to bring them into contempt, matters which advocates, incites, fosters, or encourage opposing and hostilities to organized government, or material which obstructs or interferes with the nation's recruiting or enlistment services. This gets into the military side of this, but also gets into, ladies and gentlemen, whenever that lawyer walks in and that attorney walks in and they try to use laws that is not valid, that's never been passed, they know, they are aware that it has never been passed.
And they hope you don't know that.
But
Exactly.
nobody objects.
Well, number one, most people, I've got into a couple conversations here today on this.
Well, you're right, Rod. Most people don't know to object. They don't know how to object. That's why they're on AIB radio tonight.
Yep. This is part of the problem here, ladies and gentlemen, because I have discussed this with some people, you know, and bless their hearts, you know, they listen, and then they turn, well, Rod, we need to go do this, and we need to go do that. Well, what about this? What about, did you hear what I said here and said about the statutes of not being valid, and there's no legislative law for the attorney, there's no legislative law for the lawyer to walk in that courtroom. Ladies and gentlemen, right there is your foundation for the fraud of the court.
Well, we've had these type of conversation before through the years. People, not to be disrespectful, ladies and gentlemen, but most people, and correct me if I'm wrong, we're uneducated. I was uneducated. Rod was uneducated. Harvey was uneducated. Jeanette was uneducated. We were uneducated 15, 20 years ago to all this crap. And then we got educated. And now we're trying to share a new generation of people. Do you hear what I just said?
Yeah.
We have different generations. We have different learning curves of people that sometimes they have a light bulb moment, sometimes they'll get it, sometimes they don't.
But the point being is, this is why we're sitting down to topic. Those who have ears will hear. Those who have eyes will see. We're trying to get you to open up. We're trying to get you to understand. But, Rod, what about UCC? All right? How many people on this chat board has been charged with UCC violations in a courtroom compared to those who have been charged with the United States Code?
That's a good question. What do you think the percentage is?
UCC?
Yeah, I have yet to see anybody come up to me and say, hey, Rod, I got the United States government charged me with the Uniform Code of Commercial Code violation.
No. Well, they don't, most people don't know the difference there, so.
You know, Rod, I've been charged under UCC-3.0769.
No, very few.
Everybody's charged under the USC codes. Everybody. That's the argument, ladies and gentlemen. They're not valid. There is no foundation. It was only passed by Congress in 1925. They tried 3 times to pass this thing. And the Senate said, no way, Jose. It went into prima facie. And in the statutes at large, in the volume 44, part 1, it point blank tells you that they made it prima facie. It is presumed to be law.
All right, now, Rod, here's a quick question. But you're not saying that the statutes are only prima facie, are you?
No, I'm sitting down saying the statutes are 100% correct.
Right, but the lawyers never use the statutes as their basis. They use the codes, which are only prima facie evidence of the law.
It's a presumed law, yes. This is why they will charge you under Title 18 for wire fraud, mail fraud, they'll bring in the firearm charge. But when you try to use it, they throw it out because they know it has no merit and no standing. You don't know why. Well, we're telling you here tonight why it don't have merit and standing.
That's right. Go back to the statute, read what the law says, and then go in and rebut the assumption and presumption that you violated that law. Correct?
Correct, because that Title 18, 1346, which goes into what service here, fraudulent service, that applies to them. These are administrative laws. These falls under the Federal Register. Volume 1 through Volume 50 is purely 100% administrative. Title 18 is their restrictions. And when we go after them, we have to bring them in as a real live person, not an entity, not an individual. We need to bring them in and make that court a real court. Make that judge alive. Because I've heard some of these other conversations, and the guys are coming in to where they are coming in, I am a man. And you're absolutely right. There's one thing that I did not see. I never seen where they made that judge a man or a woman.
All right, Rod, real quick. So are you saying that if we're going to be the plaintiff against them, someone else, we should charge them with statute violations rather than code violations?
Bring them in under statute, but go back and show them where their administrative code is in conjunction.
Mm-hmm.
And go back and name them as Officer Sean Nelson, the man who took an oath to the Constitution as a live person, and name him. Don't name him as Police Officer Sean Nelson.
Right. As an administration person.
Yes. You got to go back and name him as a real man or a real woman. Because once we bring in that living being and we come back in and show the statute at large side, and then we come back in and show their administrative code side where there is a conjunction between the two. This is the long version. This is your short version. This is where we're going to start seeing some difference here. But we need to challenge the prosecutor in this thing. Now, you've always heard, well, we got to challenge the presumption of law. How can you charge the presumption of law if you didn't know it was never passed? Or you don't bring it up? How can you charge, Your Honor, I'm in here to charge the presumption of law. Okay, what's your basis here? Well, I'm just challenging it. Well, Your Honor, I'm challenging a presumption of law. Here's volume 43 of the statutes at large. It stops on March 4th, 1925. According to congressional records, the USC codes were passed on December 7th, 1925 under H.R. 10,000. But I'm going to bring volume 44 into you, and I'm going to sit here and show you that on December 16th is where it picks up. So how could they have passed something on December 7th when there's no record of it? And part 1 of volume 44 comes in and its preface tells you it is prima facie law, it is presumed to be law, it is a presumption. But I can sit here and show you on June 30th, 1926, where they put it to print, but I don't see anything where Congress has passed it. So let's go down to the Library of Congress, let's go get a document here and have them validate whether it was passed or not. And they won't do that. They can't. We're going to do a foreclosure on you under Title 12 because, you didn't pay your, show me where Title 12 was passed, and I can show you where it's administrative. It only applies to your side of the courtroom, not mine. IRS, well, we're going to get you for tax evasion. Excuse me, show me where Title 26 of the United States Code was passed, because we already know Title 26 under CFR is administrative also. Ladies and gentlemen, these arguments are coming down to real simple arguments. They're real simple, basic, right down, simple arguments for standing your ground. This is not this hard. It's not this hard to understand. It's not this hard to comprehend. We're trying to make it as simple as possible. And we have come a long ways from a lot of the stuff that we were teaching. All the stuff that we was teaching was all part of this, but it has narrowed itself down into a funnel to what we've said here and brought up several times in the past. But this lawyer's book, The American Lawyers of 1907, this was the piece that we was missing. This gets in and explains that lawyer has no obligation for you. He has no duties to you whatsoever. He is in there to protect that court. He's not educated in law. He doesn't know the law. He understands theory. He understands concept. But Einstein had a theory of relativity. It took years and years later to prove his theory. He had a theory of the black hole. It took a long time for it to be able to prove that there were actually black holes out here. He had a theory. That's what these guys are taught. We're handing you the statutes at large. We're handing you the hard facts for the argument in these courtrooms. And the more of you that start standing up, start doing this on your foreclosures and IRS cases, and start challenging the fact that the security side of this thing, challenging the law side of this thing, the information is out here. It's out here for you guys to sit here and jump on. Because, there, like I said, there's a huge risk here, what we're doing here. A huge risk. All right, let me bring a caller in here. Hold on, man. Swamp Man, go ahead.
Hey, Rod.
Yeah.
One thing to clarify here. That preface is in every single United States Code annotated book except for the index. It is in every one of them.
Yes, it is.
Okay, yeah, I heard you just say it for the one volume, but I just wanted to get that cleared up. That every single one, I have every one of the volumes, and it's in every one of them.
They're telling you right up front. It's just prima facie.
Yes, sir. And the other thing, down a little farther in there, it says that any act of Congress you can rebut with wipes out any of their presumptions.
And that act,
if you read down a little farther.
Yep, and all you got to do is go in there and show it was never passed into legislation, and that knocks it out.
Exactly. Yep.
That knocks it out.
That's all I wanted. Doing great, man.
Thank you.
Thank you.
Iowa, go ahead.
Yeah, Rod, I'm looking, thanks for taking the call. I'm looking at book 44 there in the statutes at large. I'm trying to find that preface. Do you know where that's at so I can look at that?
Yeah, it's right there in front. It's as you get into the main writing, I think it's like in the preface.
Yeah, the first few pages.
Okay, I'll go back and look at it. I didn't see it in the copy I had. Thanks.
Yep.
Well, here. Let me throw a little something in here for conversation. If you go in the bathroom, judges go in the bathroom, lawyers go in the bathroom. We go in the bathroom, and what do we do? What do we do the first time we go in a bathroom? We look in the mirror. And what do we see? We see our face.
It's a reflection.
Go ahead. Can you grab it?
It's a reflection. It's an image.
You go in a store, or you go in and get gas. You got a potty, and you go wherever you go in your own home. You go in the bathroom, and what's the first thing you do?
Comb my hair.
You look at your face.
I'm combing my hair while I'm looking at my face.
Yeah. So either it's face or it's prima facie. Or it's preface. It's not a face. You're not looking in the mirror at yourself because it's not real. Because it's prima facie.
It's an image. That's all it is. It's an image. That's not the real thing. The real thing is on this side of the mirror. All that is a reflection.
Now, if that did any good, well, whatever.
All right. Let me bring this next one in. Envidor?
Hey, Rod, it's Travis from Washington.
Yeah.
I got two quick things. One, I believe the gentleman just asked regarding the statutes at large book that he has, and I wanted to clarify the preface would be in the United States Code, not in the statutes at large book, if I understand correctly. And then also an example like what Carl was trying to do is earlier in the call, at the very beginning, a gentleman was talking about a court case regarding corporations only being able to deal with other corporations. But Harvey, yourself, and Jeanette all said that no, when you actually go in and read the case, that's not what it really says. So the blurb that you see online that you read, that you take an excerpt of, that is the prima facie of what's said in the actual case. But when you go and read the actual case, they don't always match up with each other.
Okay.
Oh, that's very true. That's very true, and that's a good point, caller.
Yes.
That's all I had.
All right. Thank you. Ladies and gentlemen, like I said, we're trying to make this as simple as possible. But you've got to be able to put all the pieces together. And I know when I met Harvey here and I met Carl in person, I blew both of them away with my ability to be able to retain and put all the pieces together and be able to break it down and lay it out.
That's a fact.
I
was blown away with your ability to do that. Still am.
Yeah. This is the thing, callers. It's you've got to be able to retain. You've got to be able to remember. You've got to be able. It's like putting a puzzle together. You got to one piece at a time. But you got to remember where the pieces go and how to put it together. And this, I have the ability to come back in and do this, and I have expressed it out on this show quite a bit. And if I'm out, and Carl's seen me, I'll sit here and whenever we've done some workshops, I do not have a teleprompter. I do not have cards. I sit here and I go from memory, and I lay all this stuff out. But we have narrowed this down, ladies and gentlemen.
I remember that trip we made to Washington, D.C. we was out there on the patio. Of course, it's not like a deck or a porch patio in our houses. I mean, this thing's huge. It's marble, and Rod's out there talking about. He's got about 7, 8 people around him, and this guy walks up with an AK-47 and stands there beside us. And so I'm over here to the side, and I'm watching this, what's going on. I'm thinking, okay, we're going to be arrested or what? And this guy with this AK-47 is standing there listening to Rod. You remember that?
Yep. And it just blew him away. We was rattling this stuff off and explaining it to the people. But ladies and gentlemen, we have been trying to reduce down, and everybody out here in the movement, they have been putting their pieces in this thing. And because of all the pieces that has been put in, has allowed me to sift it down into the basics and bring this down into a smaller and tighter argument, down into a tighter foundational argument. And the gentleman that was here sit down and says, we can remember years ago when we was told we're supposed to challenge the presumption of the law. You just blew the presumption right out the door the moment you sit down and showed where it was never passed. And you have the proof, you have the evidence, you have the congressional records. It is written in that one volume where they try to codify all the statutes of the statutes at large. They try to codify them into the United States Code. And that is the only volume where it will sit here and it will tell you in the preface, it is prima facie law. It is presumed to be law. And it's all about them trying to codify the statutes at large. The statutes at large is the real law.
In other words, it's fake.
That's exactly right.
Fake law. That's the abbreviation of prima facie. Fake law.
Yes.
It's all fake. People, wake up, smell the coffee, and have a light bulb moment. That's what Cy said on Duck Dynasty.
This is what we're trying to get you people to understand, ladies and gentlemen. We don't have to jump through all these hoops. We don't have to do all this hocus pocus, abracadabra, rub your belly, pat yourself on the head, and jump on one foot. All we got to do is walk in and say, excuse me, we got an issue before this court. I want the prosecutor to produce the legislative law that created the USC codes under Title 26 or Title 12 or Title 18. I want him to produce the legislative law, the documents from Congress that says this stuff was passed by both houses. I want to see signatures. I want to see proof. Because what I have in my hand is a statute at large that shows that it was never passed, and it says it is prima facie, it is presumed to be law, it is a presumption, and it means it's not law because there's no documentation that shows that it was ever passed. There is documentation that shows that it was printed, but just because it was printed don't make it law. And here's the proof. Either rebut it or validate it. And ladies and gentlemen, they can't.
Crawford versus Washington. Remember that? U.S. Supreme Court decision, 2005. Hey, where's the body? Where's the body with this paperwork? Prima facie, congressional records. You know, where's the body? Here. And as much stuff that Rod has filed in many, many court cases, I've filed, you know, other people have filed through the years, they don't want to go there, but they want to put an ankle bracelet on us so they can show where we're going.
That's it. They want to sit down and keep track. Let me bring Delaware in. That's no good. Delaware, you got a real bad pitch in your cell phone or your home phone. Must be your fax machine. But ladies and gentlemen, tonight's call is basically to get you to understand this stuff is not that hard. It's not that hard. We're telling you exactly where this stuff is at. It's up to you. It is up to you to go back in and stand your ground on this. It's up to you to go head to head on this. It's up to you to go back in and say, excuse me, I want to see the legislative law that created this lawyer. Where does this man have any standing coming into the courtroom? Well, he's got a bar card. Excuse me. Bar card is a private association. It is private. It's members only. What gives this man the right to walk in here? I'm not association, and I'm not asking for membership. If this is strictly for the bar, then you dismiss my case. Otherwise, this man takes liability for it, and anything that comes down, he's the defendant. He's liable for it. His butt gets thrown in jail. Because it is a fact, unless you can prove it wrong, the USC codes have no standing, no merit, because it was only passed by Congress, and they are purely administrative. They only deal with public officials. These are your restrictions, not mine. Now, if this man wants to argue this, you better prove that I'm a public official. If you can't, or I'm not a contractor, then you've got no standing in here to drag me in this courtroom. But no, my attorney has not showed up from D.C. because I sent him this information. Ladies and gentlemen, it's like I said, this stuff is not this hard. It is not this hard. We're reducing it down from arguing the fact of the 14th Amendment that I'm not a 14th Amendment citizen and it don't apply to me. Don't apply to you anyhow because it wasn't passed. It only applies to their side.
And that's why they screwed up the 13th Amendment.
Exactly.
But where do state judges get their pay?
They get it from us.
They get it from the taxpayers.
Which there can't be any tax money because there's no money. Because the state of emergency clause, they stripped us. It is our credit line that they're stealing. It is our credit line that they're collecting payoff of, because the reality of it is if these people had a half a brain and they would really stop and think about it, they're collecting Federal Reserve notes just like you and I. They're not collecting gold and silver. They're not collecting platinum. They're not collecting diamonds. They're not collecting oil. They got Federal Reserve notes, so they haven't been paid either. And I went down to the bank here and I did some checking, and the guy would never use the word Federal Reserve note. He used the word U.S. currency.
Yeah, right.
As if it has something to do with the United States.
Yes.
Yeah.
They used the word U.S. currency, not the word Federal Reserve note.
Did he have a blue tie or a red tie?
He had a blue tie with a gray jacket and white shirt.
Yeah. Well, he went to college and got his degree or decree.
Yep. Let me bring in Texas here a minute. Texas, go ahead.
Hey, Rod.
Yeah.
I sent you, as I did in the previous call, the Texas Lawyer's Criminal Handbook. 3 pages. Did you get them, or do you know? Have you checked?
Whenever last call, my internet got hit Sunday. It got hacked.
I got your. I'm way ahead. I got your new email. But
okay, I've been down here for this off and on here for the last couple of weeks with medical. My health's been up and down on me.
I'm really, been praying for you on that one. 'Cause I knew something was wrong.
Yeah. But I don't. I get into that. This is the time of year I start getting into laryngitis. I start getting into my coughing spells, and when I start coughing, I don't talk to people on the phone much because I don't ever know when it's going to start up. And right now, I got some stuff to suppress it, but it don't last long, so I'm not going to be on here much longer.
Okay. Would you accept some suggestions from me?
Yeah, go ahead.
You've heard of MSM? I've suggested it before.
Yeah.
Okay. It's a very important substance because if it wasn't in the ground, everything would be a desert out here in the world.
Yeah.
And start my morning out with almonds, walnuts, sesame seeds, a lot of other things like bananas and strawberries and stuff, and I put it into a smoothie with almond milk, no sugar. And there's people that have not had a cold or flu or any problems since they've been doing this, like MSM first. I mean, that ought to clear up a lot of your problems because the powers that be are seeing to it that you're not getting it. And that's methyl sulfonyl methane is what MSM stands for. Now, it sounds terrible, but if the Father hadn't put it in the ground, it would be a desert out here in the world, Rod, and all you that are listening. So, for me, the Select brand is the best. Don't get it from any of the the box stores, and the capsules. Look for 100% pure. My favorite brand is Select, which over the internet is way higher than what I get it for, but I can't find it. That you're not getting a good deal on the internet.
Yeah.
Unless you know how to play. And the feed stores may be a good place to look. But from what I'm hearing from you, Rod, that would be a good place to start. And if you want to contact me, I've been at this for 35 years on the health and the law thing. And like I say, I'm not bragging. I was appalled at what the so-called medical profession is doing to us.
Right.
And that's why Dr. Oz is on the television. It's because Oprah even got pissed off and said, no, she's got enough billions of dollars to where she can put in whoever she wants to on TV. The doctors did not want him on there. And then there's another one called naturalnews.com. We're going to have to start learning how to take care of our own health because the medical profession is not going to do it. And neither is Bomb Care.
Yeah, that's a fact.
This Bam Bam don't care. Okay? and it's all about the money and destroying the economy and ruining your livelihood, as far as I can tell.
Yeah.
Now, if I'm wrong, somebody come in and rebut that.
How old are you?
I'm 64 and going on 20 in my brain.
Yep. All right, appreciate it. Well, yeah, send me something over. Like I said, I got that new email, but I got hacked here Sunday, and I got a hold of AOL, and I had them find out why I lost all my email on AOL and see if they could retrieve it. They said I got hacked by Germany.
Okay, I sent you Gmail.
Okay, yeah, that's the one I need. I made that new after I found out I got hacked.
Yeah, I got that. I sent you the Texas Lawyers Criminal Handbook.
Okay.
It's 287 or 286, and which talks about where there has to be an affidavit under pains and penalties of perjury before a warrant can be issued. And if you got that, then I'm going to send you a court order where the Court of Appeals in Texas said that I should have never been arrested, much less had to go through a trial, discovery, and many, many, many other things, and then had to appeal, and they remanded it back to the trial court for dismissal. Not for another trial, but dismissal, which left it wide open for me to sue. But you can't find a lawyer or an attorney to prosecute the state for their criminal activities because they're a fiction. But what I wanted to say about the lawyers and the the attorneys.
That's what I used to do.
Is that we have found out, and we've gotten prosecutors to say, well, we're not trained in the law.
No, you have to sue the prosecutor. Yeah.
Trained in procedure, and Carl knows this.
You have to sue the prosecutor.
People that have eyes to hear, eyes to see and ears to hear, know this too. And like you say, Rod, this is the problem. If you have eyes to see and ears to hear, you can hear Rod.
Okay.
I can hear him very clearly. I can hear Carl. I can hear Harvey. I can hear all those that have eyes to see and ears to hear. Go ahead, Carl.
Well, what I was going to say is I have a FASA. I don't have a prima facie. I have a FASA. I know what the FASA says. And when you go and you try to get I just lost my thought. Trying to be nice here.
Don't get nice. Just tell it like it is, Carl. Pull the lawnmower blade out, Carl.
Lawnmower. Yeah. No, you have to.
I always tell them this, Carl. What's the matter? You can't see me? They want to know the name. Well, you want a name that's registered, right? No. You look at me and see if I ain't flesh and blood. And you can see, if you can't see me, then you're a fiction. I'm not a fiction. And like Rod's doing right now, he's bringing out that everybody in the court and everybody involved in trying to screw him is real flesh and blood. Now, they don't like that because they like to play their little magic tricks.
Mm-hmm.
And Rod's bringing it out real well. And Carl, good to see you back. And Rod, please let me know whether you got those pages or not. I can send them through the mail.
Okay.
But I thought that I could send them, by email, and you could copy them and send them out to Carl and Harvey and everybody else, because those pages out of the lawyer's handbook are telling you that if there's no affidavits under pains and penalties of perjury, there can't be a warrant, and there never is. I've never seen one. That's all probable cause, probably cause affidavits. No, it ain't worth the paper it's written on.
That's why I tell people the Crawford versus Washington. Use it. Don't abuse it, but use it. It's a U.S. Supreme Court decision back in 2005, and it's major. Hey, where's the body?
Well, this lawyer's handbook. Finally, but the lawyers don't use the handbook unless you make them use it.
Yeah.
I got a court order from the Texas Court of Appeals that says right according to their lawyer's handbook. I mean, I never should have been arrested.
Well,
sign a phony ass, phony ass bond to get out, which they use to, like Rod and Jeanette says, the securitize zone and run through the stock market. I didn't know all that back in the 80s.
No, most of us didn't.
Right. All right, let's move on. Thanks, appreciate it.
Thank you, Rod.
All right, thank you. All right, ladies and gentlemen, this is, like I said, we're getting into the nitty-gritty here. All this other stuff that we're dealing with the UCC and the 14th Amendment, that's all sideline. What Texas said is the fact that they have to have an affidavit, has to have a warrant, have to have a bond. All this is fact, but also it comes right in. They have to produce the legislative law that shows that it was even passed legitimately. And that's really the last thing they want coming into these courtrooms. But ladies and gentlemen, you and I don't have a choice anymore. Trying to be polite, trying to be nice, trying to go do the 14th Amendment, trying to do the UCC, trying to do all these other things that has merit, they're not paying attention to it. The only choice that we have now is to flat out say your laws are not valid. Here's the proof, here's the evidence. And put it on the record, put it in, and address it. Bring in the fact that that lawyer doesn't have standing in that court because there's no legislative law that allows him to come in. And if they're bringing up the Bar Association, excuse me, that's a private organization. That has no merit in this courtroom.
Amen.
Because what you're telling me here is that the bar is running this court, not Congress. We're going to have to get down and start getting down to the point and quit dancing around all these other avenues.
Well, that's like we talked before. We have to come up with some funding to get 10 billboards around Washington, D.C., around the corners, the 10-mile square, that says, reenact the 13th Amendment.com.
Yep, we need to. Well, we're trying to get the finances up. We're working on it. All right, ladies and gentlemen, this is going to be a short call here tonight. We're about an hour and a half into this thing, and I have pushed my limit bar as far as I'm going to push here tonight on this. But, ladies and gentlemen, if you don't understand it after what we explained here tonight, there's no other way of explaining this. There's no simple way of laying this out. These are your arguments. Challenge the fact that the lawyer doesn't have authority to walk in a courtroom. Where's this legislative law? If you're dealing with a federal court case, challenge the USC code. Show them where that is never enacted. Show them in the statute at large, Congress said they're prima facie. They're presumed laws. They're a presumption. Here's the proof that they was never passed. There's a proof that you passed them to have them printed, but just because they're printed don't make them law. And here's your book that when you printed them, you sit down and put them under a patent. You trademarked them. You copyrighted them. So in the moment you did that, you no longer made them laws. They're private. They're not public laws anymore. They're purely private laws. They only go for the administration. That's where the Federal Register comes in. That's where the Administrative Committee comes in. That's where the President comes in and has codified all this stuff. They're purely administrative laws. How do they apply to me? These are the arguments that we need to get into. These are the arguments. These are the arguments that we need to push. I want to thank you for being in here tonight. Like I said, hear what was being said. Go back and see for yourself. These are your arguments, ladies and gentlemen. These are your arguments. Have a good night here, and I'll let you know when we have another call. Thanks. Good night.
Thanks, Rod. Thanks, everybody.